Ladies and gentlemen, it's 10:32 on my clock. I suggest we get started. We have a full panel ahead of us. My name is Boué. I represent BSA, the Software Alliance. BSA is the global advocate for the software industry, representing companies that help every other company to do business around the world. And thus, for us, privacy, global regimes are of critical importance. The panel this morning that for which we have a very distinguished bunch of panelists will be about the global equivalence of data protection regimes around the world. How do we create bridges between these different international approaches? So we've seen, over the last few years, privacy has become a much more prominent issue, public policy, and very high in the agenda of governments around the world. So, the question as to whether the GDPR efforts in Europe, where actually kicked off all this movement, is hard to say. But we've really seen a lot of movement in this regard. We've seen, for instance, over the last years, Brazil was looking at updating their privacy laws 4 or 5 years ago. We had Japan, who just updated their PIPC legislation last year. The government of India is currently looking at updating their privacy law following a Supreme Court decision last year. But we live in a global data economy. I think the companies that I represent are clearly at the center of all this. And for our economy, the way that our system operates today, one of the most important elements is data flows, ensuring that data can flow across borders. This is valid. People think always about tech companies and how the tech companies do that, but it's not just about tech companies. It's about every single company today that uses some kind of a software, from financial services to insurance to sometimes things that we don't think about. Agriculture, for instance, relies more and more on data and the ability to transfer data across border. Now, a lot of the data will be personal. Some of it will not be personal, but privacy plays an extremely important role in this regard. And as the different governments and different regions around the world are looking at their privacy regimes and trying to upgrade them, it's important to ensure that they can all interoperate to allow, and that they are good enough for one another so that data can flow between them. There's one element that we probably will not talk about this morning, but we still all remind ourselves that as we are also trying to think about, let's upgrade our regimes, let's ensure that they work with one another, there are some challenges to existing data transfer mechanisms in Europe. We think about, for instance, the moral clauses that are being considered in a court in Ireland that will go to the Court of Justice of the European Union in a few months. We think about the privacy shield between the EU and the US that is also under challenge, and so on and so forth. But for today, really, the purpose of the panel is how do we, as these governments, these regions do look at new regimes, improving their regimes, how do we make sure that they are at least compatible? So in order to kick us off, and I will introduce the panelists quickly already, and then we will go in order. So we'll have Vidhya Sampath from Tata Consultancy Services. So Vidhya is the head of the corporate and European affairs for Tata Consultancy Services across the entire of TCS's European operations. Before that, she used to be the director for external relations for Europe and the head of marketing for TCS in Benelux. And Vidhya has also been, in a previous life, a private consultant where she advised several major corporates and public institutions in Europe on business collaborations with India, and she's orchestrated several high-level missions to India. And I think it's timely to have Vidhya with us today because, as a representative of a multinational that's headquartered in India, that is looking at updating their privacy law, I think the perspective that she can bring will be extremely valuable. Our second speaker will be Monika Kuschewsky, who's a partner at Squire, Patton, Boggs, global data privacy and cybersecurity practice based in Brussels. So Monika is a practicing lawyer. She is focused on data protection and privacy, including GDPR compliance, international data transfers, personal data breaches, but also the privacy implications of new technologies. So Monika has been practicing for almost 2 decades in Brussels. And she's also the editor of the Data Protection and Privacy, which is a multi-jurisdictional reference guide for companies, legal professionals, and anybody who's actually interested in privacy. That looks at that covers 46 jurisdictions around the world and how their privacy operations operate. So I think Monika will be great to give us the legal compliance perspective on how the companies are looking at privacy compliance and how does it work across different markets, across different markets that are not with the same single set of laws. We'll also have then Adam Schlosser, who's the lead for digital trade and data flows at the World Economic Forum Center for the Fourth Industrial Revolution, based in San Francisco. So at the C4IR, Adam is building an international multi-stakeholder effort to advance the formulation of national policy priorities regarding the treatment of cross-border data flows, data localization, and associated issues. So Adam has been working closely with both public and private sector to develop best practices around privacy. And he's advised several global frameworks, including the EU-US Privacy Shield and the APEC cross-border data rules, privacy rules. And last but not least, we'll have Peter Kimpian from the Council of Europe. Peter is a second national expert from the Hungarian Data Protection and Freedom of Information Authority. He's been working as an international privacy and data protection expert for the last 6 years, and he's been a member of subgroups of the Article 29 Working Party, of the JSB Europol, CSG Schengen, and other like organizations. At the Council of Europe, Peter has been carrying on dossiers related to internet governance, domain names related privacy issues, but also the modernization of Convention 108. So without further ado, I would like to kick off the panel. And Vidhya, just a quick question for you. As a representative of a major multinational Indian company that operates around the world, and as its EU representative, how does Tata Consultancy Services feel about the efforts that are ongoing? First, the GDPR entry into force, in May 25th. How does that work for you and your customers? But also the efforts that are going on in India. How do you see the two interrelate? And if there are things that India can learn from GDPR, or actually things that could be mimicked or not?
Okay, thank you very much, Thomas, for this invitation. Good morning, ladies and gentlemen. I'm very pleased to be here and share this morning with you and my other panelists. A quick word before I start about who I represent, because that will place in context some of the things I'll say. I'm from a company called Tata Consultancy Services, which is part of the Tata Group of industries, about 120 odd companies of Indian origin. And today the group has companies like Tata Steel, which took over Chorus, for example, an European company, or Tata Motors, which owns the brand Jaguar Land Rover, or Tata Tea, which owns the brand Tetley, etc. So quite a large industrial conglomerate, and very definitely a multinational, in the sense we're a global company of Indian origin. My company, Tata Consultancy Services, is the IT services part of, let's say, the Tata Group. We are today about just under 400,000 people worldwide, so quite large. And we basically write code, software, that's what we do. And in Europe, we work in about 21 countries. And typically, we work for the large corporations in any country. So it would be the big telecoms, banks, etc. What we do for them is, again, write code, write software so that they're able to do their internal processes and also serve their customers well. So for KLM, if you're checking in online, that is built by us. Please don't come to me with your complaints. But that's the kind of things that we do. We build software that help their customers. So, Thomas, you asked me a question on data protection, the different regimes across the world. Yes, we are a multinational. We are working in over 50 countries across the globe. We have to deal with different data protection regimes. There is no compliance is non-negotiable wherever we are in the world. So that is definitely true. How we work is, obviously we as a company have to be compliant ourselves. So for all those European employees, and there are quite a few of them, we have to make sure that their personal data with our HR, etc., is protected. So, and similarly across the globe. So the first measure of how we are dealing with these different data regimes across the world is internal compliance. The second one is we are working as a technology provider for various companies, as I mentioned, big corporations across the globe. In each of these countries, they have to be compliant, and sometimes they have to be compliant just like us with multiple regimes. We advise them on how they can be compliant. Here in Europe, I was looking at some cases of work we are doing. So after legal experts, such as my colleague next to me, have given their advice, systems have to be rejigged, re-architectured, data has to be discovered. Where is all the data, the PII or the personally identifiable data existing? The same databases feed into multiple applications. Who is the owner of the data, etc. So first, discovering the data and identifying it and classifying it according to the different data protection regimes across the globe. And then you go into how to then make yourself compliant. We work on several technology solutions in this area. That's our forte. That's what we do, right? That's our core competency. One of the things we do is look at an integrated framework which looks at all the compliances. You can have industry level compliance, you can have data specific level compliance, you can have at a regional level like the GDPR, also compliance requirements. So how do you bring all these together when the same data sources and the same databases are being addressed? So we try to work with our clients to find the least possible actions that have to be done to any database or a system that will help them be compliant in the most efficient way. So that's one technology solution that we offer to our clients to do this. And then there are several other things. We are working on intelligence systems. To give you an example, an Asian airlines, they have built their systems compliant with the data protection regime in their location, wherever in the world, that may be in Asia in this case. But when they have to deal with their European clients, European citizens, and somebody would buy a ticket from them, an airlines company, then they would have to deal with that data in a different way. But the systems are defined in a different way. So we work on reconciling this, and this is done through cognitive and intelligent technology, which helps, for example, in an automated way, recognize data subjects which are belonging to a certain country and allowing processes to be triggered which would protect their data in a certain way. That's something we do. And a few other technology which I'll be happy to talk about later. Apart from this, working for our clients, we also have products and we have platforms that we have built. These we are working on, just like anybody else in industry, we're working on making them compliant to the different data protection regimes. And these are some of the ways in which we are working. You asked me the question about India in particular. India, we are following obviously the development there with great interest. India has the biggest biometric database in the world with 1 billion data subjects covered out of the 1.25 official population of India. So the data stored in this database, it's called Aadhaar. Aadhaar means foundation, is personal data as well as iris scans as well as fingerprints. Now, there has been a lot of discussion in India because people are uncomfortable with this single database being linked with all kinds of other databases, the electoral database or your tax or etc. So the discomfort comes from the fact that people's spending habits or their personal preferences should not come back to be used against them. One example was that HIV positive patients in India are eligible for government support, free retroviral drugs, for instance. But to go and get those drugs, they have to then show their Aadhaar number. And there's been a lot of resistance against this because there is still prejudice. And if that Aadhaar number is used and it gets linked to a health database and so on and other databases, then they are afraid of ramifications which might affect them in jobs or whatever it is. So this led to quite a big and intense debate, which led to then a committee being formed in India under an ex-Justice of the Supreme Court of India. This committee is now looking into the different data protection regimes across the world, including the GDPR. GDPR is considered particularly strong because it protects citizens' rights. It has obviously a very strong focus on information governance. It is truly global in nature, so the protection it tries to provide is global in nature. Breach and liabilities, breach management and liabilities are enshrined in it and so on. So this committee in India is looking particularly at the data protection regimes and trying to, it's a kind of consultation, and end of this month there will be findings which will then go towards building India's own data protection regime. So I think I'll leave it there and probably come back to some of these points later. Thank you.
Thank you, Vidhya. Monika, from a practicing lawyer advising a number of companies on, you know, I'm sure that you're spending a lot of time these days on GDPR compliance. I think May 25th is around the corner. I think everyone is gearing for that. How do you advise companies who have operations around the world, and how can they ensure that the operations are satisfactory, meeting the requirements of the different regimes, and how do you do that?
Yeah, thank you, Thomas. Maybe before answering your question, also very briefly, you know, coming back to your introduction. But when I started practicing in privacy, that was you know, early 2000, you know, was all about the implementation of the current directive and how it has been implemented in all the member states. And already at that time there was a big challenge because the directive, being a directive, was implemented you know, in different ways in the EU. So that in itself already posed a big challenge for companies just trying to do this. And now we are facing a very similar problem, but just on a bigger, on a more global scale, because since then the number of privacy laws in the world has been, let's call it, mushrooming. You know, it's similar to the development in the area of competition law, where, you know, it started off with a very few countries that thought, you know, it would be good to have a law, and then you had a lot of other countries thinking, oh yeah, we should do something in this area as well. And then some countries taking completely different approaches. And coming back to the book that you mentioned, so, you know, I haven't written the entire book myself, but, you know, it was, you know, fun experience, and actually the third edition of this book, and just also to show that over the years the number of laws have been ever increasing. So I've invited lawyers from different jurisdictions to contribute chapters, and we try to follow an FAQ approach, so to be able to compare where are the differences or where are the similarities. And what I always found so interesting in editing these books is that despite all the differences, some very fundamental principles, the substantive principles, are very similar in a lot of the companies. Everybody agrees that transparency, you know, is a very important principle in the area of data protection. Everybody agrees that security is a very important principle, and so on and so forth. So control of users, you know, another element which you find back in almost all of the regimes. Now the problem comes from the fact that then the devil is in the detail, and that in the different countries that the emphasis and the focus on different aspects is different, which is again very understandable, because there's a different tradition, a different background, a different, history of countries. So the emphasis on certain aspects of privacy is traditionally, culturally very different. And and the devil is in the detail, as I said, and that is the main challenge. So what do I do in my daily practice? I'm a lawyer, I'm a partner in the global data privacy, cybersecurity practice of our firm. Squire, Patton, Boggs is one of the 10 biggest American law firms. So we have global multinational clients who are not only established in one EU member state or in several EU member states, but all over the world. And they come to us and they tell us, okay, we have a project, be it, GDPR compliance, but also be it, we want to roll out a whistleblowing scheme. We have an obligation under US law, SOX law, for accounting reasons to have a whistleblowing scheme where employees or customers can call in and say, there's a suspicion of money laundering somewhere, and this must be an anonymous hotline, and so we want to roll this out. And then, what do you tell, what do you tell your clients? Well, the first thing is you try to analyze where they are in which countries. Then you try to analyze, what are the different, laws that are impacted by this project. And privacy is one very important aspect. But of course, there are many other laws having often an impact on it, be it employment laws or other laws like on retention periods. These laws are incorporated in tax and wherever, spread all over the place. So it's an amalgam of not only the different privacy laws, but also tons of other different laws which are all not harmonized. And then what you do is you come up with a scheme. You analyze, where the main blocks are, where the commonalities are, where the main principles are, and then you identify normally clusters of countries. Let's say, on a scale from 1 to 3, the ones which have very high standards, then the other ones, which are in the middle, and the other ones which are easy, to meet the requirements. And then you work around those clusters. And then, of course, you can take, different approaches to it. You can say, okay, I want to deal with all of this on a local level. I leave it there. But then, of course, you lose, everything that a global corporation needs in terms of they want to apply one standard, they want to apply one rule, ideally, across the board, one policy. They don't want to have 157 different policies, because it's a nightmare to manage this. It's a nightmare to implement and maintain. And so they want to work with, what are the common denominators? And then the big question is, do you take the highest common denominators as your basis, and then you put yourself in a straitjacket? Or do you find a middle ground somewhere, and then you work around the local nuances? And this is what I'm doing a lot, together with my colleagues in the other offices in the world, and also external experts, trying to find the best approach for a particular organization. Also depends on their risk appetite to some extent, and then also on their willingness, to go an additional mile sometimes, or not. But so maybe I stop here and leave the rest for the discussion.
No, thank you, Monika. I mean, one of the interesting things that I've just picked up from you is basically you saying that the approaches around the world are very similar. So the overall thinking or the overall objectives are the same, whereas it's as you said, the devil is in the details, and how do you do the practical implications?
This detail. So to give examples, again, transparency, security, confidentiality, everybody agrees. But then, how do you provide notice? And the problem then is in the laws themselves, because they are sometimes very prescriptive, like the GDPR now lists, 12 different elements that need to be in a notice. And if you take another law, they list other elements that need to be mentioned, or in a different order, or and certainly in a different language. And then how do you reconcile it? So do you then add the additional elements, all the elements, from all over the world in one notice, but then it becomes completely illegible? Or how do you deal with it. So the problem in this area is that the laws used to be very principles based, and I think that's generally the best approach because it gives you flexibility on how you reach the objectives. So the law ideally should, you know, set an objective. You want to keep data secure, but then should stay away from saying how you get there, you know, which level of encryption do you use? Okay, it may say encryption is a good thing, but, you know, do you really need to have a law which says, you know, in which particular case you use which type of encryption? And shouldn't this be left, you know, to the companies to comply? And I think there was a, you know, very good idea in the GDPR originally, the principle of accountability and responsibility. So to hold organizations responsible themselves on how they achieve these different objectives, and then leave it up to them, their creativity, to come up with solutions which also fit their business. But then, unfortunately, again, you know, and some of the other provisions, they forgot about this principle of accountability and fall back into this. We have to be very prescriptive in detail. And I'm afraid to say, Thomas, there's not really a golden solution. I would be very happy to say there is, you know, I know exactly how to do it and overcome all these things. But of course, if the law says that you have to list the retention period and you have to give the name and the address of somebody, well, either you do it or you don't, right? So there's not really a way to do it. But what generally works is to, first of all, create a level of awareness in a company, identify these common, you know, where the overlaps are, the commonalities, and then have policies and procedures, a baseline in place. I think this is what you've also said, a baseline of common standards, and then see in which jurisdictions or which regions you have to do more. And then depending on the type of company, if you're a service provider, you want to show to your customers, you want to market your services, maybe you decide, okay, I don't care that in a particular country I don't have to comply with this additional requirement, but, you know, it's easier for me if I comply with it across the board, and I want to show our customers, irrespective of where they are, their data is always treated with the same high level.
Thank you, and I think, you know, so what I take from this, and I'll voluntarily be provocative, I think we are already one step closer to finding a solution. I think if our entire, if rules around the world are really the same spirits, it's just a question of, you know, different approaches. I think we're already, you know, it's not like we have radically different approaches, with radically different views on how things could be done. Now, moving on to Adam, I think from a perspective of a do tank, I think that's how the World Economic Forum is referring. You know, work on these issues of data protection, data flows, trade, etc., bringing a number of different constituents to the table and trying to find commonalities. How do you see, you know, industry, civil society, governments, do tanks, you know, think tanks, academics coming together, trying to overcome gaps in these sort of different approaches to move forward?
Sure, thanks. So I'm with the Center for the Fourth Industrial Revolution out of San Francisco, and we were created with the mandate of how do you maximize the social and economic benefits of emerging technology while also acknowledging and mitigating some of the real risks that are out there, such as related to data privacy and data protection, when the amount of data being created is just exploding. We can't even quantify really the amount of data that will exist in the next few years in a realistic term. So for example, in autonomous vehicles, if 1/4 of the number of registered vehicles in the city of San Francisco were autonomous, they would produce the same amount of data every year as all of Twitter and the history of Twitter. So you can imagine, as you expand that to an entire city and an entire world, just the amount of data that will be out there is going to be exponential. So it's really important to ensure we have a cooperative environment to deal with tough questions around privacy and protection and data transfers. And we're focused on pulling together a multi-stakeholder model of cooperation, as Thomas indicated. So it's how do you bring together all the right stakeholders at a table, industry, civil society, regulators, and when we say regulators, we don't just mean DPAs, we mean any of the regulators with responsibility for data issues. So it could be financial, it could be health related. So just facilitating that conversation between a DPA and their counterpart from the health ministry is often a useful exercise as well, because they both have overlapping, if not conflicting, responsibilities and enforcement capabilities. So that's an important process that we bring together as well. And we're focused on something called Agile governance. So how can you ensure that you build the frameworks that allow governments and regulations and directives and rules to keep up with the changing pace, the rapidly changing pace of technology. So regulators, their job is to be conservative. No one really applauds or congratulates regulators for being efficient and saving money and cooperating together to conduct a cross-border enforcement activity. So a company only deals with one regulator when they're in 4 jurisdictions. We should really congratulate that more often because it makes it easier for companies and it also saves resources. But that's kept quiet. However, if there's a data breach somewhere, every regulator involved is getting their hands smacked and getting yelled at. Why weren't you on top of this company? Why didn't you know this was happening? So how do you create a framework that allows for the efficient use of those resources and also encourages regulators to be forward-leaning, to move ahead and create the flexibility needed for the emerging technology and how to keep up with the different technology uses. So I'm happy to be the bridge between the practitioner, Monika, and my friend Peter, the government perspective coming afterwards, because we're working on some tough questions that don't have answers. So we encourage, or it's a best practice to encourage an outcome-based approach. So what is the goal? Ensure that data is protected, secure, and private no matter where it's stored around the world, when it's in transit, when it's in use, when it's in storage. However, there are a lot of open questions out there around the many rules that are being created today and how they deal with new technologies. So one open question is related to the use of blockchain. And I'll talk a little bit more about some innovative uses later, but as an example, the public blockchain, the permissionless blockchain, often most closely associated with crypto, nothing's stopping anyone from embedding bits of PII in any block that then builds upon another block, and you can't delete those blocks of information. So by the book, we'd guess that every single person, every single entity doing mining on the blockchain right now and validating transactions, if there's a previous block that contains personal information, by the book, they're probably all violating GDPR right now. But how do you enforce that when there is so many different nodes out there? How do you deal with this changing technology? However, the better use case is, or a better example is around encryption. So encryption can be considered pseudonymous data going forward. However, what if the data subject is the only one with the keys? What if the one doing the data controller or data processor can't de-encrypt that data unless the subject provides them the right to do so? Is that still pseudonymous data? Is there any incentives out there that will encourage this type of increased control and increased ownership for the data subjects? It's sort of an open question now that I'll kick over. And then finally, another question that we're grappling with as an example is around, again, the autonomous vehicles example to bring it to a close. So if you're a Japanese citizen driving a German car on an American road and you get into an accident in a semi-autonomous vehicle, the Japanese regulator requires that information to be processed and stored in Japan. The German regulator requires the information on the car to be stored in Germany. And the American Highway Traffic Safety Authority requires the accident data to be stored and analyzed in the United States. What do you do in that situation? There's not even 2 conflicting rules. It's 3, and it's not even DPAs. It's the auto administrations. So these are the open questions that we're trying to create frameworks that allows for the collaboration. And by focusing on outcomes, that's really the key to getting answers to these tough questions going forward. So that's just a little bit about what we're trying to do. And I'll leave you on one closing note of that when we say governance and frameworks, it's not all public sector. It could also be private sector. So we're encouraging the adoptions of standards and protocols from private entities. And an example of that is we're talking to a few medical data or medical device companies about how to have more data minimization. And obviously the best approach to data protection is to not have the data at all. That's something that we always say. And we're talking to one medical device maker, and they have a really new exciting product out there that does that can automatically update hip replacements and other types of joint replacements, and it could actually change how it's calibrated to suit the individual better. However, the engineers decided we need as much data as possible off this. We need to be able to analyze in real time. We need to be able to track what's happening. And they created a system where there's just zettabytes of data being created. And the practitioner, the compliance expert from the company said, hey, this is great. We have all this data now. It's not structured. We have to store it in every jurisdiction we operate because we can't tell if it's PII or not. We don't know who the owners are necessarily because it's not structured. And oh, by the way, the bill was $48 million for the extra cloud storage. So going forward, it makes sense to have data use plans to analyze why you need the data, how are you using it, and create standards around that whole sectors can work together on, and then also collaborate with civil society and government as well to jointly create those sectoral standards. So that's a lot of what we're doing, a lot of open questions, but we're excited. We think it's a really important issue going forward.
Thank you, Adam. I think, one thing that I will come back later, just want to also get Peter's perspective on that. I think jumping back on something you said, something Vidhya said earlier, I think you're looking at how technology, which is often seen as a threat or as a danger to privacy data protection, but you're trying to look at it from a perspective of, could that be actually part of the solution? Could we be using technology? Could you be using of standards in different, be it sectoral, be it horizontal, and using new, AI, for instance, to actually help protecting data, in better and smarter ways. But, before we get to that, because I think, I have a very vested interest here, I apologize, being the chair, I'm also sort of guiding the discussions, working for the software sector. I think this is something of critical importance to us because, trying to be seen, perceived, or trying to be working as part of the solution is something that we desperately really want to do. It's critical for all of us. But Peter, Council of Europe, very famous for the Convention 108, which is in the process of being upgraded or being reviewed. What is your perspective from the perspective of you are a regulator / working for intergovernmental organization? How do you see all these issues working? How do you see the role of same question as for Adam before? Do you see governments, regulators, civil society, industry, everyone sort of trying to be part of this ecosystem to advance the privacy protections that we all desperately seek and need?
Thank you very much. Thank you, Thomas, and thank you for having me in the panel. I try to be not the most boring panelist, not being the last one, but being, as you said, a regulator and coming from a legislative body. And as Adam said, we are the most conservative part of the equation, but not always. And I try to get into our work, and I have the privilege to, I think, to speak on both capacity. From our committee, which is the Data Protection Committee of the Council of Europe, which has the Convention 108, as Thomas rightly pointed out, and as the Data Protection Unit of the organization, which is an intergovernmental organization which was constructed after the Second World War as a soul of Europe, basically for the reason not to repeat the horrible things that happened during the war again. So it has to be remembered, I think, nowadays. But passing on to this, Convention 108 is the data protection privacy instrument of the Council of Europe. It has been drafted and adopted in 1981, so quite a long time ago. And even in 1981, it started by saying that the convention promotes the free flow of data within party states. And since 1981, we as the Data Protection Unit, as Data Protection Committee, worked on this and to preserve this. It was not easy in the history, but of course, I only had some reference text for this, but as I can testimony to you, it's not easy nowadays, even within our member states. But we have, as Thomas already mentioned, we have the modernization process, and if we manage to get into the final phase, which will start by this Friday, so this Friday, I will be more in a position to tell you about what Convention 108 will look like in the future. Unfortunately, this is not the case right now, but this Friday we will enter in the final phase of this process, and which will allow us as committee and the Data Protection Unit to work more on this. The Convention 108, as of 1981, encompasses standards which are in direct or in indirect connection with the 120 national privacy legislation over the world. So it is not me saying this, but there is the academics who found out that the old data protection legislation, existing legislation, having the main building blocks, which can be found in several texts, but one being Convention 108. Convention 108 is, why is interesting? It is interesting because we have several multinational and international or regional documents on privacy, like the APAC Privacy Framework or the OECD OECD documents. There are others which are being developed in the WTO right now. But Convention 108 is an international convention based and construed based upon the Vienna Convention, the Treaty on Convention, the Vienna Convention. So it is primary international law, and which is most important, it is open. So it is open for third states to join, and that is one of the added value. And currently, we have 51 member states, the 47 of the Council of Europe member states, plus we have 4 other member states coming from all over, from outside of Europe. The last member state of our party state, which joined 1st November last year, was Tunisia, for instance. The Convention 108 and the modernized one will carry on and will serve for the organization and the committee to promote this international aspects and global law aspects, global international law aspect to offer for interesting states. And I can also share the information with you that during our last plenary meeting, 4 observer status have been granted to third states which are interested in our work, being one of them New Zealand and Israel. So we are really expanding our network, I would say, and we are in current negotiation with Brazil, Japan, South Korea, and so on and so forth. So it's very, very interesting, and it's a dynamic process. It is not only the convention itself, but there is, to mention, the standard setting work of the committee, because sometimes all those conventions can be looked at from outside as the ivory tower, that very interesting, but very blur principles, as Monika pointed out, or are put forward by binding legal instrument. But we in the Council of Europe, we have a committee which is doing a standard setting work, which tries to explain to legislators and to practitioners how these provisions was meant to be implemented. And in this, I can cite some of the latest work the committee finalized. We have a recommendation on the processing of PNR data. We are, the committee adopted a guidelines on the use of big data, and we are about finalizing a recommendation on health-related data and a practical guide on the use of data within the police sector. So we can say this is a wide variety of topics that we try to deal with. And last but not least, I would like to mention one of the new initiatives of the Secretary General of the Council of Europe, of course, which was supported by all the services as the data protection unit as well, was an exchange of letters with big companies, with big telecom and internet companies and their respective associations. So the Secretary General of the Council of Europe signed a letter of intent with them in order to include them to our processes, because we are of the opinion that good policy or good legislation can only be made if it's inclusive. So we have already extended cooperation with civil society, with other governments, but it was something missing. Some big part was missing, and now we try to fill the gap and bring big companies on the table. How it will work out, it is a question for the future, but you can count on us that we will push for it, because we feel that it is very important, and we have to channel all those input into the legislation, for that it's not that conservative or not that retroactive in our very rapidly changing digital world. Thank you very much.
Thank you, Peter. I think, you just reiterated the point that we're seeing, convergence around, major markets, most of the markets around the world, with maybe the exception of China, towards, some rules that would be similar. Now, jumping back to the idea of technology, I think, so there's really there's a few things here that I'm very interested in, because technology can certainly help. Technology is a manner to streamline a number of operations, and can be helpful in compliance, helpful in enforcement. At the same time, there's if we're using standards, if we're using technology, how do we ensure that we also create incentives? How do we ensure we ensure that there's innovation that keeps happening? Because more often than not, governments will be looking at technology as a solution, but they will want to mandate it. Will mandate certain use of tools, or of certain standards, certain technologies. How do we work together to ensure that there's a real engagement between society, regulators, governments, academics, to try to use technology as a tool to be helpful? Vidhya, I don't know if you want to.
Thank you. So it's interesting because the way the GDPR, for example, is constructed, it enshrines citizens' rights to really be at the core of it. And that itself is an incentive for innovation. So what we see on the ground is that companies have to work really hard to, as I mentioned, to discover where the data is, to classify it, and then to make themselves, rejig their systems, re-architecture them, so that you can comply, so that you can extract the data, so that you can, be able to, provide for the right to be forgotten, et cetera, et cetera. But what this also does is provide huge amount of business opportunities for companies. So the very fact that your data can be retrieved in such fine grain and so detailed towards one data subject allows for companies also then to provide specific, extremely customized service offerings to those data subjects. So that's one thing we see, that a lot of customers, so telecom companies, for example, et cetera, or banks, they use this as an opportunity to be able to devise new go-to-market solutions for their customers and use it as a differentiator. The other thing I'd like to say is that we worked on something that I think, to use your words, Adam, which puts more control in the hands of data subjects. So we devised an application, a solution called Crystal Ball. So what Crystal Ball does is it's a personal data management system that a telecom company can, for example, offer to its customer. So if you sign up for, I don't know, a mobile phone, they can say, hey, but you know what? You can also use this service that we have to manage your personal data in real time, record what data of yourself you're sharing with us, and change any setting that you want. So a telecom company can offer this in a way to, I think, showcase their dedication to transparency and to keeping their customer data secure. So the innovation also comes from the opportunities that customers see. It's sort of a process that we are watching happening.
Thanks. So to answer your question with high-level principles, I think it's important that we look at technology-neutral solutions and focus on the risk of the type of data, the type of transfers, the type of uses. So taking a holistic view. So what type of data is being used, how is it being used, and for what context when creating the rules and frameworks, and the implementation guidelines for that type of data. So a couple specific examples that are in development, and then I'll give you one just sort of nirvana long-off use case for data that I think is very exciting as well. So one of the things we're working on is addressing the root causes of data localization. So one of the very valid causes is a lack of clarity around cross-border enforcement. So regulators, rightly so, wonder what happens when the data leaves their borders. How do they ensure that their regulations are being followed on different borders if they can't always see the data, they can't reach in? You know, my practitioner friends will say that, well, we have a large compliance book, we do it electronically, we send you those records. But there's often a gap in the trust area. So can we use a distributed ledger technology and just, I don't know if it's oversimplification, but again, this isn't necessarily blockchain or cryptocurrency based. So all blockchain is a distributed ledger, but not all distributed ledgers are blockchain. So you could do private nodes. So you only have one or two trusted parties, or maybe more, that are part of that distributed ledger. So working with the ledger technology, you could have one company, one industry group, working with a regulator, and if they choose to, also maybe their civil society counterparts as well, to show that every time data is used, collected, accessed, analyzed, you register that transaction to the ledger. So you can provide real-time access to that regulator. Show, you know, look, the data is being moved worldwide and being analyzed, but it's encrypted the entire time. It's stored in these databases. And if you are concerned that something's happening, here's how we'll give you access to that database in real time. So you're actually seeing compliance worldwide in real time, and you're sharing it with the regulator, and you're doing it in a secure and safe way where you're not providing access at all times or creating security risks to your network. You're just showing the compliance piece. So that's one way in that this new emerging technology can actually be used to improve the cross-border issues and increase privacy and security while answering concerns related to data flows, data localization. Another area use case out there is related to distributed queries. So this is the idea that the data itself remains static, but you send out and you create remote algorithms that conduct the analysis. They could do machine learning to develop better types of findings with the data. And the only thing moving is the code for that algorithms. So there is, MIT has an open source software program called Project Opal. And they have a couple use cases with the telecom industry and the transport industry. And we're developing something around medical data. So for clinical research, how can researchers create treatment plans based on data that's stored in different jurisdictions, and the only thing moving is the algorithm. And they could also combine that with insights from data produced by wearable and mobile technology. So you could have certain types of biometrics on your phone. It's secured. No one touches the data but those you give permission to. And you could still have researchers and clinical researchers create diagnosis or health plans for you, personalized, while you control the data the entire time. The only thing moving is the algorithm. And you could even share that algorithm with the regulators to show that PII is not being touched. So again, it's a collaborative environment, and it's creating solutions that are cross-border data flow problems, while again opening up new technology uses. And then a longer-term solution set, possibly, is again combining distributed ledger technology with AI and creating a sort of a marketplace where you wrap your individual data in a permission structure that says, you know, my data is worth X, and you create a token value for that. And I want to allow uses for, say, either health research purposes, or you could say marketing purposes. You could create you as a data owner can create your own type of use cases, and I want to allow it for this amount of time, indefinitely to these type of companies, 1 month, 1 day, 1 hour. And you could create a marketplace by where industry groups or researchers or academics saying, we're looking for this types of data subjects, this type of data sets, and you could send out the remote request. It's a matching marketplace. And in turn, it tokenizes the value of that types of data. You can have a bidding system, and the data subject can have both ownership, control, and monetization of their own data. And that last example is, the technology is not there yet, but if we're thinking progressively, it's an example of how emerging technology can be used to both empower data subjects, solve privacy and protection concerns, and really make regulators' jobs easier as well.
Yeah, I think, you know, all of these are really great examples on how, you know, companies can address it, and, you know, very good example of privacy enhancing technologies, you know, which the regulators are very supportive of. I wanted to give a few other more legal examples on how convergence is being achieved, or, you know, rays of hope that I see there, and maybe bring it back to the GDPR. So obviously, you know, one element, international data transfers. So for those of you who know, there are these restrictions on data being transferred outside the EU to what we consider non-adequate countries. So the mechanism of adequacy in itself is already, I think, you know, an example of, you know, allowing for convergence. Now, the question is, how is it then interpreted in practice, and how difficult is it, you know, to achieve that adequacy, you know, threshold, you know? But, you know, I think the idea not to require identical laws, but, you know, essentially equivalent rules allows, in theory, for some flexibility. And then the problem is, if it's then interpreted in such a way that it's essentially impossible to reach unless you copy the GDPR letter by letter, but then we end up again with, you know, okay, it's a great idea, but, you know, we are losing that opportunity. Another example being binding corporate rules, which is an international data transfer mechanism for companies. So if you don't want to sign, you know, hundred thousands of different contracts, you know, within your group of companies when you transfer data abroad, you know, to your IT center and in the, you know, HR databases somewhere else, one data transfer mechanism is model clauses. So you're signing, you know, multi-party agreements, you store them in a drawer somewhere, and that's it. There's another mechanism called binding corporate rules, where a company says all the companies that are part of the group abide by certain principles, and these are again then based on the principles you find in the Convention 108, in the GDPR, you know, a set of different principles, and the company itself ensures, you know, enforcement and the possibility to complain. And this binding corporate rules idea, I think, is another mechanism to get to convergence worldwide, because what a lot of our clients do, and what I see a lot of companies do, is they don't only apply these rules, these internal rules, to EU data or to the, you know, to EU originating data, but they apply this across the board also for local data in, you know, in South America and in Asia, because they say, you know, we don't want to treat our employees, for example, differently. So this is another mechanism to bring conversions, but by essentially exporting the GDPR principles to other areas of the world. And then there's a similar mechanism in the APEC region. You know, the abbreviation, I had to note it down because it's the cross-border privacy rules, so CBPRs. And, you know, there's been work going on by the data protection authorities to come up with a referential where they're comparing, okay, what do BCRs, the binding corporate rules under the GDPR require, what do these CBPRs require? And then they ended up with, okay, they are actually quite similar. What the real problem was again the process. How do you get those approved? You know, you have to talk first to all these authorities in Europe, and then for the CBBPRs, you have to talk to all the authorities, you know, in Asia, and there are different application forms. So the problem wasn't so much the substantive principles again, but, you know, all these formalistic procedural requirements. But, you know, they are working on having one standard form of application, and I think that's a very good example on how regulators can also make it easier for companies to achieve that. And maybe a last example, I remember in 2015 I was in Amsterdam at the conference, international conference of privacy commissioners, and there some academics presented you know, their report on what they called privacy bridges between EU and the US. So I think, very, fits very well into our panel as well. And they have been looking, so academics in privacy, looking, at the different frameworks, but coming up with some principles how to overcome those bridges. And not surprisingly, the ideas was to deepen the relationship between the regulators, and I think that's crucial that these regulators talk, because sometimes they simply don't understand that other regulators think differently. If I go to a German data protection authority and I tell them, if I put this provision in my BCRs, then I will be sued in America, I will have a class action, lawsuit, and, this will cost my client millions of euro, and then, or dollar, I should say, and then they are just staring at me and they don't believe me because, under German law, that doesn't exist. So it's a lot of education still being required, but they make a lot of efforts to talk. This international conference of privacy commissioners is a good network. They have the global privacy enforcement network, GPEN, which works together on these enforcement actions. So I think these fora where they exchange ideas and their approaches are crucial to create sensitivity for the differences in approach and identifying the commonalities. And then the other things they mentioned, and that fits well to what you were saying, is user control. Give control back to the users, new approaches to transparency, to really be transparent about it, and develop best practices. And I think certification, standardization, that's other new elements and mechanisms in the GDPR where companies, I think, should take the opportunity and come up themselves, developing codes of conducts, standards, certification, which then allows them to apply this on a more global level.
No, thank you. And I think you're right. Talking about convergence, I think there's a lot. One of the test cases that we'll see on how the essentially equivalent tests that came out of the CGAU and the Schrems case, Schrems 1 case, will be the Japan EU adequacy determination. I think Japan has a very similar but somehow different. And I think if Japan passes the test, I think there's at least from I'm going to step out of my neutral role here. From our perspective, it's going to be a positive development. If it doesn't, then I think we may see some problems in the horizon, some clouds in the horizon. But that being said, I think looking for bridges where we can have them, I think is particularly important. One element that Adam you mentioned, which I would like to put Peter on the spot a little bit here. You mentioned the agile development of policy, the agile view that I know is dear to the World Economic Forum. I think it's something that is dear also to software sector because it's a way of developing software. It's harder for lawmakers, for regulators to look at this in this particular matter. But in light of the fact that conventional way is very principle based, how could you foresee some kind of agile being brought into this? And I'm sort of voluntarily asking you this question. I know that you probably will not be able to give us an answer, but I would like to get your first reaction to how could we talk about this thing in manners that would make that or that could bring it closer to reality in the coming years.
Yes. Thank you. Thank you for the question. I think that my primary answer would be to continue the standard setting work, which the committee already started, is carrying on, and wish to continue, but in an inclusive manner, and to have more and more stakeholders in the committee as observer, and where possible, and we speak about states or nation states that become party for it. I can give you the example of the big data guidelines we developed last year. It was a very, very tough discussion within the committee, and it was very difficult to even to start this exercise, as it was very much out of the traditional area of data protection, starting from the definition of personal information within big data, analytics environment, and so on and so forth. But we managed within the committee to adopt this text, which is maybe not the last one, but was in this area. And the committee adopted this as subject to further review, if need be. But I think this kind of approach and this kind of as you mentioned, the principle-based approach complemented by practical guides and soft law measures, as we call it, opinions, recommendations, guidelines, can be a way forward. As, for instance, we even had the Philippines sitting as observer at the table, so it will go very far around the world as possible reference to their work as practitioners and as legislators in their country. The second one is the international cooperation. I think it is very important. The international cooperation within data protection authorities, within governments, of course, and within interested stakeholders. And the other aspect would be, for me, to mention is to keep this on the political agenda of the political forums, as it will be very important to see it as an important point, and to have developed agendas which can work for throughout the world for different governments.
Thank you, Peter. I realize that we are sort of running out of time. I think we have about 5 minutes left. I would like to now open up the floor for questions. I don't know if there's anybody who has a question for one of our panelists. If you do, please identify yourself and ask to whom and specify to whom you're directing the question.
Hello, thank you very much. My name is Janja Viskovic. I'm a data protection lawyer with the International Committee of the Red Cross. My question is probably directed at the members of the panel who are speaking from a more legal perspective. One of the things that the GDPR does not appear to deal with is the conflict of laws. Are we going to face a situation where, for example, an entity that potentially is bound by laws in one state outside of the EU and potentially caught also by the EU, and where a conflict of laws exists, how you see that being dealt with, and is it really just going to be a matter of who has the strongest regulator in force?
Yeah, actually, that is already a big headache today, and I don't think this will go away under the GDPR. I think it will just become more complicated. To be frank about it, in the past, it was a rather easy solution for some companies. You know, if you were confronted with a government request in the US to hand over some data, and then the possibility of imprisonment, and they shut down your company, and you have 20 years, a monitor or something, opposed to no sanctions or 500 euro sanction in Europe if you violate data protection law. The choice was often a risk-based choice, and I think that is now much more complicated. So I think it's a matter of being creative. So to really think like, does there really have to be a conflict? So starting with, do we really need to hand over personal data? Are there ways to anonymize it, to redact certain things, data minimization, to then talking to the different authorities involved, and especially those requesting the data, and trying to inform them about these rules, and there's work going on in certain very specific areas like e-discovery litigation, where these conflict of rules come up, and US think tank, the Sedona conference, already dealing with it for many, many years. But yeah, these conflict of rules will continue to exist, and with the big force of sanctions, enforcement action possibilities that the European authorities have, it's definitely not getting easier. But I think it will force companies to more openly seek the dialogue with the data protection regulators and ask them for help. And that has already been happening in the past, but essentially, really going there, telling them, look, I have these issues, and then working together with them on a solution. And there have been, in these conflict of rules areas, data protection authorities, they are aware of it. They don't want to put companies in such difficult situations. They are often, very helpful trying to overcome those difficulties. And then it's probably a matter of more closely cooperating, and again also educating, in the other countries where those conflicts exist, to educate them more about the difficulties of companies. But I mean, we have all these cases pending, Microsoft or wherever, where under the current rules, and this is definitely not going away, but becoming worse, I would say.
All right, so if we have 2 minutes, I think, thank you for bringing this like dark clouds after this very optimistic panel. What I found was we were leading to solutions, and now, this sort of creates a more uncertainty. But jokes aside, I think I would like to give each panelist maybe 20 seconds each to close off and to give their sort of final statement on this, and on how we can continue to work to create bridges to ensure that different international approaches do not conflict or conflict with one another in the least amount possible, in order to ensure that our global economy and the way that our society operates today, continues to do so for years to come. So, start with Vidhya, yes.
So obviously, building trust and dialogue between governments is a good idea. Consultation with industries, people like us who are watching on the ground what actions industry is taking, that's a good idea. I'd also like to quickly say that building citizen awareness is something that we see from our perspective a little bit too less of. So GDPR is there, it enshrines citizens' rights, but do citizens know enough that about what their rights are, and building support advocacy so that the breach cases become also clear. From that one can learn and be agile and hopefully improve on the existing legislation. Thank you.
Yeah, maybe to add on to this, I think it's really the matter of continuing the dialogue and increasing the dialogue, talking to people, raising the issues, thinking about solutions, and it's this exchange of ideas which normally has the best outcome. And then I think the second thing is to always sit back and think, what is it actually that we want to achieve? Do we want to have this box ticking exercise? Okay, I comply with everything, or how can I achieve, this more control of a user? How can I achieve more transparency? And, to think about innovative ways, new approaches to it, thinking out of the box. And this you can only achieve again by talking, not lawyers among lawyers, but lawyers talking to, IT, talking to engineers, talking to the HR, to the business, to the function. And just then, by this exchange, you often come up with solutions you haven't thought about when you were sitting on your own on your desk.
So in the interest of time, I will strongly echo and agree with everything Monika just said. That's completely accurate and fantastic. And I'll just add one little piece and say, it's important to be flexible as to the different uses, intended uses and benefits of the data. So it's not all just search engines and social media that's being used, but it's, as Thomas started with, it's every aspect of the economy now, and there's a widespread amount of benefits out there. So let's try to focus on the end objective of data privacy and data protection, and figure out the best path to get there, and how to use technology for good, and how to build that type of convergence overall going forward.
I really can. I only can agree with both of the previous speakers. The confidence and trust is key, as well as breaking silos is is the best way forward. As Adam was mentioning, that we also, I personally think that we have to see data privacy and data protection as part of the broader data governance equation or solution. For that, I think we have to have, and the committee and the unit I represent will have a proactive and innovative solution. So we have to find the solutions and which will preserve the same level of protection as offered by the current applicable legislation.
One phrase. Oh, and my phrase for the year 2018, we're moving past data protection. It's still very important, but data management. It's the whole system. How is it used, being collected? It's not just protection. It's user access, it's security, it's everything. So buzzword 2018, data management.
Thank you very much. And maybe one thing to one of the key takeaway as well from this that hasn't been mentioned, I think the use of technology on how to ensure compliance, to ensure protection. I think one thing that I always certainly remember is the use of distributed ledgers for accountability. I think, Adam, you didn't say accountability, but that's exactly where you were leading to. That was very telling for me, at least. Well, with this, I would like to thank you all very much. The panelists did a terrific job to provide their insights on these very complicated topics. I would like to give them a huge round of applause. Thank you.